focuses on government contracting and helping government contractors with a whole range of issues that arise during their government contracting journey. It's been a pleasure to get to know and to work with Sheena and her company and the different folks that she's referred to me. My law firm's called Gebo Law LLC. I also have a non-lawyer consulting company called GCARL LLC. We can talk about the difference if that comes up, but that deals a lot more with coaching, teaching, and instructing people rather than actually representing them with their government contracting and legal issues.
Yes. So what he's saying is, he can help you with your business and government contracting, also be your attorney, but they can't really overlap all the time, right? That's pretty much how it works.
Exactly. And I just want to say this, as Sheena said, I am her attorney. I do represent her. For all those viewing, I am not your attorney, or at least not yet. So anything I say today is not legal advice to you. So just please, bear that in mind. I'm going to try to be as forthcoming, as I can, but just want to be clear that the only person I represent here today is Sheena.
That's right. You heard that. Okay. And just share a little bit about your, he's a veteran, of course, we like veterans all over. I feel like most of the people I have are veterans, but that's just, what we attract, but it's a beautiful thing, nonetheless. So share a little bit about your veteran experience or your military.
Sure.
Experience.
I went to the University of Notre Dame on an Army ROTC scholarship. So when I graduated, I had an obligation of time I had to serve and was fortunate enough to be selected into the aviation branch. Wow. So I went to flight school and served for about 6.5, 7 years as an Army helicopter pilot. Wow. When I left the service to go to law school, I was a captain. While I was in the Army, I was in in Korea for just over a year. Was in Panama for Operation Just Cause. That was the whole Noriega thing years ago. Then I was in Operation Desert Shield and Desert Storm in Saudi Arabia and Iraq, and was stationed for about 4 years at Fort Bragg and saw just about every swamp on the eastern seaboard. and before I left, I was able to play on the All-Army soccer team based out of the Presidio of San Francisco, and then left and went to law school at Northwestern in Chicago, graduated from there, and then followed a job opportunity to Atlanta, passed the bar in 1995, and have been a government contract attorney here since then. Started off at some large law firms, was partner at 3 different firms here in the city, working in government contracts, construction, and commercial litigation.
Man, this is a resume I didn't even know about. So you can fly too. Carl is just the best. He can do everything. I'm telling you, you'll find out here shortly when he starts sharing some of his experiences and some of the contracts that he's actually seen, some of the crazy stories. I tell you guys all the time to, the agency is not necessarily the expert. You are the expert in your field. So it's really, really important that you follow the rules based on your industry and your job that you're providing for the government, and don't let them take over when you know better. So I'm too excited. So I need to hear that story again that I heard originally with the guy with digging in the ground. Go ahead, Carl.
Sure. Well, I've had clients in all different kinds of industries. I've had folks who have sold frozen seafood products to the commissary system. I've had folks who have done batteries for air-to-air missiles, folks who have done different staffing projects, who have provided, when I say staffing, it could be IT staff, it could be PhDs working at the Centers for Disease Control, or it could be just staffing in a medical facility to give additional support for in the hematology labs, or as nurses, or as X-ray technicians. I've worked with some of the large defense contractors when I was at large firms who represented Raytheon, Lockheed Martin, Boeing, Northrop Grumman, all those big major defense contractors. And how I got into representing more smaller contractors was a common thing we noticed from working with the large guys was they seemed to get in trouble with their small business subcontractors because the small business subcontractors didn't really know or didn't have the internal support to understand all of their compliance requirements. So if you're a government contractor, whether you're the prime or the sub, you are responsible to meet the same compliance requirements as Lockheed Martin. And so what happened was these large companies had to have a diverse supplier and subcontractor base or participation. And those small companies kept getting into trouble and getting the prime contractor in trouble. So they asked us at the different firms that I was at to help them train or create a university where they could develop small business subcontractors into legitimate government subcontracting partners. And when I saw that that was where they were going, I said, well, there's a whole market that is unserved, that there are new companies that are successful in the commercial space that want to come into the government space, but they don't know how it works. Others who are in that status and certified realm of 8A, HubZone, SDV, OSB, woman-owned small businesses who have a lot of opportunities. Those are very valuable statuses, but they typically don't have their own general counsel. They don't have their own compliance officer. And yet they're being asked to sign contracts that have pages and pages of FAR clauses that are part of the contract. And they were only learning about them after they were in trouble. So
of course, who's reading all that at the beginning? Nobody.
Right. So my goal was to try to put together a place, Gebo Law, that would help these folks figure stuff out on the front end.
Okay, so
one of the things that we, as a helicopter pilot, that you learn is like, if it ain't right on the ground, it's not going to get any better in the air. So
I love that. Okay, so I want to pause right there really, really quickly because I get it, right? Because I am that small business and I've used your services, and I might have step A, B, C, and then skip over to M and M and O, and I'm like, okay, there's some stuff in the middle that I'm missing. And so basically, Carl is explaining that we're held to the same regulation no matter what size we are. So you can't cop out saying that, well, I didn't know, and this goes back to some of you all that are doing the subcontract. You're subbing the work out to a company that you don't know. So they're still going to be held to the same standard. You're going to be held to the standard. You can't just say, oh, my sub over there, they don't know what they're doing. So, oh, well, no. We are all held to the same standard. So you have to be extra careful and make sure that you're reading your contract. Make sure that your sub is understanding the contract as well, and they're reading a contract that you have amongst each other. So just make sure that you guys are understanding what you're getting into when you sign these documents. And make sure you guys hit like on this video. Go ahead, Carl.
Sheena, that's a great point of emphasis. If I can just amplify that with an example. Many of the folks might have heard of E-Verify, right? This is a registration that government contractors have to do to let the government know that all their employees are legally employed people, right? That they have the right documentation to be employed, to receive public money as an employee of a government contractor. That typically flows down to every subcontractor on that job. And I've had clients who's like, oh yeah, we know about E-Verify, but we're not a federal contractor. We just do work for MARTA. So, well, I'm sorry to let you know that MARTA receives federal public dollars, and that E-Verify is actually, that requirement is also part of a Georgia statute that gets incorporated into the MARTA contract and is required to be flowed down to the subs. So even if you don't think that, I'm not doing work for the Air Force, or I'm not doing work for the federal government, you could still have that kind of, that E-Verify requirement is a requirement even in something that might look like a non-federal government contract.
So some of the local contracts you're saying kind of cross over to federal like standards?
Yes.
Wow.
And
So
I've
in
had
multiple
clients working with MARTA that ran into that. Also, folks providing, for lack of a better term, I'll call it human services. So people working with the youth, right, who are giving what they call wraparound services. A lot of that money comes from the feds, and when the money comes from the federal government, that's federal regulations and statutes that have to be complied with.
So
right?
how do we know that, Carl? How do we know?
Well, it's going to be in the contract, but you should be asking those questions as early as possible. And you should always be looking for, where's the earliest I can learn about this specific opportunity. A lot of times, the first time a contractor hears about an opportunity is when they see the solicitation, or they get a call from a prime contractor that says, I'm looking for a sub. Well, a lot of these opportunities are budgeted for, and they are forecasted, and that information is public. So you can learn what the CDC or what other federal agency is forecasting for the whole next fiscal year. Like they may be coming out in the third quarter of 2024 with an opportunity that may be of interest to you. So you can do all kinds of, due diligence or capture strategy to learn about who's the incumbent, what was that contract price, who is also interested in this, who's the decision maker. Perhaps I can introduce myself at a conference, or make an appointment with that agency and talk to their small business liaison. There's all kinds of stuff that you can do to learn about opportunities as early as possible and prepare yourself for all of the things that can make your bid a winning bid, but also, and most importantly, a compliant bid.
Wow. So, that's interesting, because that is more on like the capture side. And I didn't think that you were going to get into that, but it's really good because, I talk a lot about bidding on my channel. I do talk about some capture, but it's more like, action after you see the solicitation, right? So it's, speaking of capture management or capture, like you said, what do you think, if you could give just like a quick, because we're not going to get deep into that, but if you can give a quick 5 steps of, how the best way to capture, like you mentioned a few things, introducing yourself, like knowing about an opportunity, maybe when it's time for it to cycle back around after 5 years, like a quick 5.
Right. So the first thing that you want to do is learn about the opportunities that are in your wheelhouse, right? So first you have to know yourself, and what are, it's not, can I do this, right? Because you can convince yourself that you can do anything, right? But can I do it well? Can I do it compliantly? And can I do it at a price that is competitive, that also makes me money?
Look,
I've had too many clients win contracts that they regret winning.
Oh, yes.
Because they priced it so aggressively, they were losing money. Yes. So those things are what you need to bear in mind when you see an opportunity, and then to map out your strategy for how you're going to not just capture, but perform. Are you going to do it by yourself? Can you do it by yourself, or do you have to have more hands and a higher head count? Or do you need a subcontracting partner?
Right.
Do you need a particular license or certification to be able to perform? Can you do that with a subcontractor? Maybe you form a joint venture that can go after it. Now, you can't do that in the 30 days from when the solicitation gets posted and when you have to submit your bid. You have to know about the opportunity as far in advance as possible to assess it, and then map out your strategy for how you're going to bid it, win it, and perform it.
The performance is really when the rubber meets the road, right? Because
Yes.
you're like, okay, this is way different than I thought for one reason or another, right? Whether it's like maybe I didn't think about the pricing or I had to change out a person or two, or the subcontractor went to hell and now I have to find another one and I don't have enough cushion for, they were cheaper labor and that type of thing. So those are really, really good points. So I want to, so Lena, I'm not sure if that answered your question, if that's what you meant, but we have one more question here. If you are the prime, do you drop your own contract for your sub, or do you use the same as a prime contract new to GovCon? So you want to take that?
Yeah, that's a great question. I'll give you a little story.
Yes, we love
I had
the
a
stories.
client of mine who was in the IT area, and they developed software solutions for federal government agencies, and they were new to government contracting. And what they did was they took their prime contract and they changed it so wherever the word prime, wherever their name was, or wherever the government's name was, the government agency, they put their name, and wherever their name appeared, they put their sub's name. So what they were essentially saying was, every single thing that I am responsible for as the prime, I am going to make my subcontractor responsible for. And I don't recommend that.
Okay, that's my next question.
Because the actual scope of work of the subcontractor was much, much less. They were only doing maybe 20% of the actual work. Now, where it saved them was on all of those FAR provisions, that's federal acquisition regulations, that were incorporated by reference into the prime contract from the federal agency. So it can be a page or pages and pages of funny looking regulations, right? And then it has the name of it, right? Like one will be like the Whistleblower Protection Act will be one that will be in there. Another will be the Davis-Bacon Prevailing Wage Act that will be incorporated by reference, because they just cut and pasted every single thing that was in their prime contract into the subcontractor's subcontract. They were protected because the subcontractor could not deny that they were aware of the obligation. Problem was, you don't just want a contract that covers your ass. You want a subcontract that actually helps you get the job performed the way it should be performed, and that is in compliance with the requirements. So at the very fundamental level, just passing down, cutting and pasting your contract into a subcontract with your subcontractor might cover you, right? But I wouldn't say that's a good contract because it's not tailored. And you need to ensure that your subcontractor understands what they are required to perform. Not just that, well, I told them and it's on them. Well, that just means you've put off your fight to another day, to the first time that your subcontractor screws up. So to answer the question, I would recommend drawing up your own subcontract that incorporates the required and important provisions into the subcontract from your prime contract.
Yeah, that makes a huge difference. And I'll just, if I can add, a lot of the contracts are going to be, some of the contracts, because especially with me being in cleaning, they're going to be very broad. And, once you get into the job, or sometimes you'll get into the job and realize the agency didn't know that they need more. And so now I've contracted that out or subbed that out to someone else, and it wasn't in the original. So like you said, you're putting off the fight to another day because that they are also responsible for, DEF, but you didn't put that in there because you have that original one from when you guys first started. So that is like extraordinarily important, because people get real smart and they know how to read when they're trying to get over. So just make sure that, just like he said, make sure you have something that makes sense and airtight. Everything is cute and cool and everybody loves each other until there's money being exchanged. I'm just telling you that includes family, friends, and all. So we have a few more questions here, Carl, and then I'm going to start asking my questions. So good evening to everyone. Lena said you answered her question, so we're good with that. Good evening to everyone that popped in a little bit late. So Lisa Brown said, can you address, I hope you know these FARs, Carl, regarding the limitation on subcontracting, new to GovCon as well. I keep hearing different things. What's the best way to be protected? This is like one of my favorite questions, but go ahead.
Yeah, let me tell you, limitations on subcontracting. I'm very familiar with this topic. In fact, I have presented at a national conference, gosh, for 8 years this coming November, and we've presented on this exact topic at least 4 times. Limitations on subcontracting applies to federal government contracts that are awarded on a set-aside basis. That means that the government is saying the only companies that are available to even bid on this opportunity have to be of a certain size and type. And that usually is either 8A or small business or woman-owned small business or disabled veteran-owned small business or hub zone or Native American or tribally owned entity. So you'll have, if the procurement seeks only to make an award to a specific set-aside group, then the limitations on subcontracting apply. And what that means is that if you're going to subcontract, there's a limit based on whether you are delivering products or services or certain kinds of specialties subcontracting. So for services, it's 50%, right? That you can to subcontract. Now, if you are subcontracting to a similarly situated entity, which means that's a small business that meets the same requirements as the prime, then any amount you subcontract to them does not count as being subcontracted. It counts as if it's being performed by the prime. So say you had a woman-owned small business set aside and you had a WOSB company win. If they find a subcontractor that's also a woman-owned small business in that NAICS code, those two companies can perform 100% of the work, no matter how they split that up. So the prime could do 10%, the sub could do 90, but it's not considered to be a subcontractor performing the work because it's a similarly situated entity.
That's okay. That's beautiful. So I kind of knew that, but I didn't really know the way you just explained it. So there's nothing that we have to put in place. Like if the agency sees that I'm submitting with my proposal that there is a, subcontractor who's also WOSB, then there won't be anything coming back saying you're still overly reliant on the sub or anything like that. That's not gonna count. Or is that a separate conversation?
Well, this limitation on subcontracting is really related to performance. And what you're suggesting or you're bringing up there is the issue of an improper affiliation or an ostensible subcontractor relationship where the prime is unduly reliant or overly reliant on a subcontractor. Now, here's the thing, this will typically happen where the prime has problem demonstrating that it can perform the work. Okay, I had a client and they came to me after they had already lost the bid, won a contract, got protested, lost the contract, and then came to me for help. So I did what I could for them, but what essentially they were doing was they did not have, this is a staffing job, and they were typically providing kind of those human counseling services. But none of the people that they had on staff had the degrees or the experience dealing with, this was specifically dealing with childhood trauma. So they were good for like general social work, general, counseling, things like that. But when it came specifically to like post traumatic for children, they had nobody that had those credentials. So what they did is they brought, and this is a set aside contract, they subcontracted to the incumbent. So the incumbent had all those people and had all those managers. And what my client tried to do was say, oh, we are going to subcontract to them. And they identified the subcontractors' managers as the managers for the work. And so when the government said, no, wait a minute, you yourself don't have the ability to actually perform this work. You're only meeting the threshold requirement by unusually reliant on your subcontractor, because you don't have not a single person that has ever treated a child age or a minor aged person dealing with a post-traumatic situation. And so they lost the contract. And that was based on that improper affiliation rather than a limitations on subcontracting. Had they had one or two people with the credentials that could have performed the work, then at least they wouldn't have gotten protested, or at least not successfully. And then they would look at whether or not it was a limitations on subcontracting issue. In that instance, the incumbent contractor was not a small business at all. That was the other problem they faced. Oh. So limitations on, if you want to think about this, the affiliation part or the unduly reliant part is the front end, and the limitations on subcontracting is the back end. How you perform and what percentage gets performed by who is the question that gets asked. But you can avoid that, or at least put off that question, by ensuring that on your proposal, you are demonstrating that you are qualified as prime, and that any sub or whatever you're going to sub out are to people that are similarly situated entities, or at least to that required percentage of performance.
Wow. So I'm glad that you separated both of those, because I guess I merged those together. So that's kind of what is it, Okira Shockley? Make sure y'all don't forget about the super chat, and make sure you hit a like on this. He is dropping like stuff that I didn't even know. And I talked to Carl. I didn't even know all this stuff. So what I'm understanding from, the Barney perspective, because I need stuff broken way down for me. So a lot of people are new to GovCon. What you said, you explained it exceptionally well. But just to give another scenario to what he's saying when it comes to being overly reliant, I was actually I was one of those. I'm transparent on this channel. I was one of those. And so if it shows that it looks like a pass-through where, yes, I am a SDB or SB, I'm a woman-owned, and I am going after this contract for heavy construction, never done heavy construction in my life, and then I have a sub that does heavy construction, that's all they do. And I'm like, yeah, we're going to do this together. The government is not going to, usually sometimes they might turn a blind eye, or they might just say, okay, let's hope that they do what they're supposed to do. But when you're getting up into the millions of dollars, usually they're going to look very, very closely at, okay, what is going on with this company? It only shows that she's done, I don't know, $100,000 worth of work. The other company's done $10 million worth of work, and this is a $10 million opportunity. That looks really fishy. So she definitely is relying on the subcontractor to do everything. And what happens if the subcontractor drops off the face of the earth? Now what? She doesn't have necessarily the money or the skilled labor to perform this contract. And we need them to perform this contract because it's a whole lot of money. So is that kind of what you were explaining as well? Did I do a good job?
Yes, that was right on point. And that's a very good example, because a lot of folks who have done can lay claim to doing work on some kind of construction project, like maybe you did the cleanup of a tenant improvement job, right? It's like, oh well, I was on a construction project, so now I can be a prime on a construction project. And it's like, well, maybe not so much. And then particularly if your number one sub is a heavy civil construction company, it's going to raise questions with the agency. It's going to raise questions with the people competing for that bid. Like, wait a minute,
right?
How is Sheena going to perform this work? I know Sheena. I've seen the contracts she's won.
Yes.
And I know the kind of work that she's capable of. How is she all of a sudden capable of building a VA hospital? by herself. Right.
And
So
that goes back to that middleman stuff that y'all be talking about. And I see that there's some, I just hate that word. We don't use that on this channel. But let me go through a few more questions, and then I'm going to go to my questions. So I think, Lena, I think he might have answered this. Do you hire a lawyer to create the contract for the sub? You want to answer, Carl, or?
Well, this may be one for you, but I often am asked to review subcontracts for my clients. So typically, I mean, a lot of the contract of any contract are going to be business terms, meaning what is it that you need your sub to do for you, right? And I've done a lot of things, but I haven't done what Sheena has done as an owner of the company that performs the services that they perform. So she knows better what she needs from that company for them to actually do what they need to do to help her meet the obligations of the prime contract. So a lot of it is going to be coming from that owner of that prime government contractor. There's also a lot of stuff that goes in there to protect you, right? As the person who is issuing this subcontract, right? Protections for when they get paid. How do you determine when the work is done? What is the timing? Who are they allowed to communicate with, right? All of those different things, as well as and I'll give you, here's a perfect example. If, say, Sheena has a company and they are providing staffing of some sort, and they are staffed at a remote facility, and they are directly, those people, her subcontractors, employees, are directly interacting with members of the agency. And the members of the agency start telling those folks to start doing different stuff that's not in the contract. If your subcontract doesn't explain to them that they are only authorized to take direction from Sheena or Sheena's project manager for that contract, you could get into a world of hurt in that kind of a situation. But that you can hopefully instruct and direct and contract your subcontractor not to do that.
Listen, I'll tell you, I have had to dish out a lot of money because of loose lips to the lowest person that was pushing the carpet cleaning machine. Got us in. I don't even know what the heck would even possess someone to say some of the things that some of these people will say. And that is like so real. It may seem like, oh, what's the big deal? No one's going to talk to the 21-year-old who's, respectfully, who's pushing the lawnmower. Yes, they will. And I don't know why agencies do that either. They may not be able to find you at that 1 second, and they're pissed off, and they're like, hey, are you guys going to do this? Oh, no, such and such told me that we're not going to do that for this project. And now the agency is like, their hair is on fire, and they're losing their mind, and like, who told you? Blah, 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 blah. So that is so incredibly important. Like I said, I've had to dish out extra money because people were giving the wrong information to an agency or whatever. Like they just didn't know what the hell they were talking about. So this is more of just a regular GovCon question, but I'll give my answer for this. Been on IT contracts. If your registration NAICS code is janitorial, I personally know that I've been called out for not having the right NAICS code in my SAM for what I bid on. So always have the NAICS code in your, registration for what you're going to be bidding on. But you shouldn't be bidding on a whole bunch of different stuff. Anyway, that's just Sheena talking. But go ahead, Carl. Do you want to add?
Yeah, and there's different philosophies on what you should list in your SAM registration. I would say list as many NAICS codes as you are capable of performing. So if your background is in IT and you think you can perform IT services, absolutely include that in your SAM, because you can. There's no limit on how many NAICS codes you can have on there, but you don't want to undercut your own credibility, right? By saying that you just list every single NAICS code that there is. Now you can have very diverse capabilities, right? And you should have capability statements that reflect the different verticals of services that you can provide. But yeah, if you want to try to win a contract, that NAICS code for that particular opportunity has to be present in your SAM registration somewhere. Doesn't necessarily have to be your primary NAICS code,
Right.
right? But it does have to be there.
Yeah, and I mean, I got lucky because I think we bid on like a laundry one, and the contracting officer, lucky me, but he called and was like, "Hey, you need to add this to your SAM registration." And it takes what, 24 to 48 hours for it to update. I think it's a lot faster now, but you want to have that in there way ahead of time. So, Lean, I think he might have answered your question as well when we talked about the subcontract, and that's always a topic. So, is it Legend Webby said, I saw a video the other day that said the middleman, we don't use that word, basically subcontracting, needed insurance. What type of insurance is needed, or does it vary? You want to take that?
Okay, yeah, I'm a little confused. I'll take a stab as I understand the question. Yeah, every government contract is going to have different insurance requirements, and oftentimes you will also have to have what's called a performance and payment bond, which guarantees the government that if you don't perform or you don't pay the subcontractors, there is somebody, typically an insurance company or a surety company, standing behind your representation that you're going to perform the work. So if you go out of business or can't perform for whatever reason, there's a place that the government can go to get the obligations remaining on the contract performed. So it does depend from opportunity to opportunity, and that'll be in the solicitation document for you to look at and to understand. But again, if you're looking at subcontracting, if you're the prime, you want to ensure that any risk that you cannot control yourself is covered by insurance. So if you are looking to your sub to perform and to pay its people, then you may want to pass down the requirements for insurance or bonds to them as well.
Yeah, and I think one of the rules of thumb, because I think I know what you mean, Legend Webby, that like it goes into the question of W-2 versus 1099 and then subcontractors. And basically, if something happens on the job with one of your subs people and they don't have any insurance, whose bill is that? That's your bill. That's you. You're coming out of pocket for whatever the workman's comp requirement is, or anything to do with damage to the facility. If you're doing facility stuff or delivering products, that's going to be your bill. So that's the question that you ask yourself. If I'm trying to give someone a chance and I know they can't afford that high ass workman's comp, just know that that's your bill, right?
Yeah, and insurance that's a whole nother topic. And there are specific insurance products that are available and required if you're doing work on a military installation, on a Department of Defense facility. And there are, and I would recommend nothing against State Farm or Allstate, but you should not necessarily be looking to the person that is selling you your car insurance to provide you insurance for the risks you face as a government contractor working on a federal government facility. There are other insurance brokers who are out there. I can share those with you, Sheena, or we can post them somewhere that are people that are very, very knowledgeable in that very unique space of providing insurance coverage to government contractors.
If you can, just a few off the top of your head, please share. Some of the ones that get it, that understand.
Yeah, I will. There's a gentleman here who's in Atlanta that I've known for a number of years, and I will have to look up his contact information.
He's a broker.
Yeah.
Okay. So, do you know of any like insurance companies that might? So, I'll just say for just business insurance, I personally use Hiscox. I'm not saying necessarily like it's the best, and they don't focus on government contracting, but as far as business insurance, I use Hiscox. And then Cover Wallet is a broker, like an online broker type thing. So they'll find insurance for you as well. So just general business insurance. But as far as like government contracting, we'll wait for the replay of this video. Who's watching this on a replay, I'll hopefully have it in the description by the time this gets posted. So cool. All right. That is great. So the next thing is, and thank you, Lisa. She said this is excellent. Don't forget the super chat, y'all. Super chat. And there's 42 of y'all on this. Several people have jumped in and possibly jumped out. So make sure you hit a like if you haven't already. Carl is dropping some super gems. Like we can't even cover everything. Go ahead.
Sheena, if I wanted to go back to one thing regarding the limitations on subcontracting,
Sure.
I saw a question flash up there about paying 50% of the work, or it's 50% of the contract price. Great question, really a great question, and it does depend on the type of contract. And I'll use construction here. Construction is considered a service, but it has, for construction, you can subcontract up to 85% of the work, but you don't count the cost of the materials.
Oh.
So if you had, I became a lawyer because I thought there wasn't going to be any math, but if you had a $100,000 contract, right, to do some construction, and like 50,000 of that was materials, you would have $50,000. That would be the amount that you could subcontract 85% of. It'd be 85% of the 50,000 of the non-material cost of the project.
Got it. Where's my mathematicians? Go ahead and do that math for us. 85% of 50,000. I'm not a mathematician either. Go ahead and somebody do that math for us and drop it in the chat. But that's okay. That's really great to know. So it's of the labor. It's not of the materials. And I can kind of see how those things are separated, because I've talked about on my channel before how I was able to get an advance for a contract for materials only, though.
Yes.
You know, that's technically what it was supposed to be for. So they do count that kind of separately from the contract, if you will. Okay, boom.
And Sheena, the Insurance Office of America is a brokerage that does handle and specialize in government contractor insurances.
And what is it again?
The Insurance Office of America, IOAUSA.com is their website.
Okay, make sure y'all make a note of that so you can, you know, hopefully you get like a kickback or something, Carl. But and we'll leave a note in the description later on for the replay of this video. So Jack Turner is asking, if I want to do work in other sectors, would you recommend getting another LLC formed so you could be known as a specialist?
Another great question.
That is a good question.
If we're not considering certified status small businesses, and I'll touch on that in a minute why, but excluding that for now, you can have as many LLCs as you want, and you can have them cover different areas. So someone feels like, oh, if I'm going to your ABC LLC, oh, I know that's for janitorial services, and you have all the capability statements, you have a separate website and that, and then if I'm actually going to do food service under the XYZ LLC, you can see how people probably don't want to have the food preparers and the janitor people like in the same LLC, right? And you'll probably have different certifications. Here's the trick when you're talking about small certified status having companies. What they look at, the SBA typically, and also the contracting government agency, is looking at, is that company, is that specific LLC, is it owned and controlled by a person who qualifies to own and control that kind of a status company. So if you are a woman-owned small business, right, and you own one company, and you have, and your paperwork shows you 100% owner or 57% owner or 51% owner, you're good to go. And you can demonstrate that you have the experience to be able to know how to operate, manage, run the day-to-day and the strategic vision. You are good to hook. Now, you start adding multiple companies that you own. The question becomes, how can you have the time, energy, expertise to be able to actually manage on a day-to-day basis the operations of 5 different companies that are in 5 different disciplines? You maybe you can, probably you can, but if you're going to go for what's like the highest of the statuses, which is 8A, they want that 8A company that the SBA is certified to be your primary, if not exclusive, business focus. They don't want to hear about you having ownership in some other company, that you are running and you are managing. You might have a side hustle, and that's fine, but you can't say, oh, I have this 8A company that I'm 100% owner of, right? Because an 8A program is only for 9 years, and it's supposed to be not just to get contracts, but to develop your ability to be a business owner and have you off on these far-flung enterprises owning 51% of 4 different companies in different NAICS codes. So depending about what environment we're playing in the non-status, have at it. Have as many LLCs as you want, so long as, again, as you are credible. In the small world, we're talking about 8A, veteran-owned, disabled veteran-owned, woman-owned. You have to be very, very careful about how many additional entities you're going to represent that you can do the day-to-day operations and be in charge of their strategic vision and be able to do that without Peter robbing from Paul of your time and your energy.
And I'll tell y'all, I used to do certifications back in the day for companies, and they will check. I mean, I had one guy, I did I think I was doing either the Hub Zone or the SDVOSB certification. And this was just a few years ago. Now they're looking at your social media. They looked at his LinkedIn. He had like 4 companies. He worked 2 jobs, still in the military, and he wanted to start another company and get certified. And when you do a certification, for those who have done one, sometimes they'll come back and ask a bunch of questions, and you got to write a letterhead stating, answering the question. He had about 10 explanations. And of course, I was the one that was doing it for him, but they were asking like, well, if you have 2 full-time jobs and you're in the military, how are you able to focus on this business? You have these other businesses, you have real estate. How are you able to focus on this business? And they want to know, like, what hours? Is it from 9 to 5? Is it from 6 to midnight? Is it Monday through Friday? Is it Sunday to Sunday? They want to know. So to Carl's point, it's more than just like, oh, I have a whole bunch of LLCs and then all of them are going to be doing different things. They're going to, they're watching. They're looking at, what is your focus going to? Because you're in a special league of people who qualify for a set aside. So,
and just to amplify that point, I was just chatting the other day with a gentleman who was just leaving the Navy after 8 years of service. He was looking to, and he's a disabled veteran. He's looking to get into government contracting, but like right now, he has, de-roast the service, so he has a full-time job that he has to show up to and punch a time card.
Ooh,
and I said, boy. I understand, because you're an entrepreneur, and most entrepreneurs have a job as they are starting their other enterprise because they got to keep the lights on.
Right.
And I said, well, look, there's a lot of stuff we can do to help you prepare for when you want to drop your application, when you want to get registered in SAM. But before you do that, you need to cut ties or become no more than part-time at that other job, because that is incompatible, having to be at Target, Home Depot, or a factory where you have to punch a time clock and get there at 8:30 and you can't leave until 5. The government's not going to say that, oh yeah, you can do that and be an owner. Now, the differences in the obligations of an owner and an employee does make a difference. So that you can, like, if I'm going to own a company that does whatever, staffing services, and then I own another company that does janitorial services, I don't have to be 100% of my time from 9 to 5 each day doesn't have to be dedicated to owning my ownership responsibilities of the staffing company.
Right.
Okay. Doesn't take 24 hours a day to be an owner, but you
Right.
have to have some amount of time during the workday that you would be able to say, yes, I can from 9 to 12, I do this company, and from 1 to 5 or 1 to 8 or whatever, I do this, and I'm available with my phone to be able to do whatever comes up on whatever projects of either company. That's fine, but you can see you can only juggle so many things, as particularly as a one person show. So
Right.
it becomes a very real question for entrepreneurs when they're trying to make that bridge from, okay, how do I like keep the lights on and eat, and then when and how do I launch my small business, SDVOSB company as a government contractor?
That's right.
And
All that.
oftentimes the answer is they launch without going after government contracts.
Yeah.
And they are looking for private contracts or commercial contracts from commercial clients and customers, build up a base. And then so it's like work for Home Depot and be an owner, but don't go after government contracts, get some commercial clients, quit Home Depot, service my commercial clients, and now look for federal work or government work.
Yeah. And I would even say, to add to that, like the local side, they usually don't care. If you're getting a certification, they may, depends on which one on the local side. But local contracts as well, could be a way to build up. I mean, or it could be, you could do that exclusively. We live very heavily in the local space. And it's, it feeds the same to me. I mean, there's millions of dollars on the local side, just like there is on the federal side, and corporate and commercial and all that. So,
Absolutely. And I would say that, I mean, one of the things I tell to entrepreneurs is 100%, you absolutely need to at least consider and research whether or not it makes sense for your business to sell to the government. There's too much money coming from all different levels of government contracting for you to just ignore that potential opportunity. You have to at least consider and do the research for it. Now, adjacent to that, there are companies, large companies, that have contracts with the federal government. Because they are federal government contractors, they have an obligation, and they have to report annually on the percentage of small business subcontracting participation that they have. And every year they have to have a goal, and every year they have to have a plan, and they have to show how it is that they are striving in good faith to meet those percentage goals. As a service provider or a provider of goods, you can sell to those commercial companies, those large commercial companies, but they're going to want to be able to rely on your representation that you are small, that you are woman-owned, that you are veteran-owned, and gone are the days of people just taking your word for it. So getting certified by a third-party certifier or the SBA is very, very, that's the gold standard in those commercial supplier diversity programs. So again, they may not vet you like the SBA will, but many of them will expect you to already have been vetted by the SBA before they allow you to participate in their supplier diversity program. And that can be just as lucrative, if not more, than going directly for prime contracts from the government.
Right. And so remember, y'all, that the supply diversity program is hinged usually on the corporate side, and those are the certifications you have to pay for, where through the WeBank and the veteran ones, I can't remember. Novova.
Yeah, the Hispanic Chamber of Commerce is another one. WeBank, the U.S. Women's Chamber of Commerce is another one. Those typically come with membership fees.
Yes.
But those are the Minority Supplier Diversity Council.
GMSDC. Or
GMSDC is one in Georgia.
Georgia, yeah. So those are the ones you got to pay for, anywhere from, I believe it starts at some of them are $50 all the way up to $500 a year. So I always tell people, don't pay for a certification on the corporate side unless you want to do corporate. You might not even know what you're doing. You're like, oh, I'm just going to pay for this certification. You don't even know it's corporate. You think you're doing straight federal contracting, but it's corporate contracting. You're not going to get, DOD with that certification.
Right. So, but the corporate side will accept, if you're 8A through SBA, the corporate side will accept that. If you are a DBE through in Georgia through GDOT, they will accept that in the commercial space as well, but not vice versa.
I didn't know that.
Yeah.
I did not know that. So that's really
And if you are a DBE in Georgia, that has reciprocity with other states where they have an abbreviated process to become a DBE in South Carolina, Alabama, Tennessee. So you don't have to go through the entire process all over again. So and those certifications are very valuable.
They are very valuable. People will come looking for you. I just did a video on that. So if anybody's DBE, drop DBE in the chat. I'm DBE, and we did start going through that cycle through the Southeast, at least we started with. So if you're DBE, go ahead and drop that in the chat. So let's see. We have a couple more questions. So Lena was asking about I think the 50-50, but also 85% of the project cost, but not including materials, right?
That is for construction projects.
Construction.
So that's not just for general services. That's specifically for construction.
Right. Yep, that is true. And then LaDon Malone said, I'm having the hardest time with Cage. I don't want to use my home address and I can't afford to pay for a real office. Is there any in between? I know what I want to say.
Well, I'll tell you what, there are and there are not. Okay. Things you cannot use as an office address is a post office box or a UPS store box, which they call a suite. I know because I have one.
I have one too.
what you can use is a Regis office space, but it has to be one where you can receive mail, you can meet people, and they can, if they had to, they can serve you with legal process. Right. So it can't just be, oh, well, I have a Regis office space, but my lease only says I get to use this address, but they don't receive mail there for me. Okay. So your lease contract has to be such that you have the rights to have an office, even if that office changes every day. You have the right to have an office. You get mail there. It would be good if there was a phone number associated with that office that somebody answers or they direct it to voicemail for your company. And that will be sufficient.
Yeah, I was wondering about that myself. So I was looking at a WeWork. I mean, Regis, WeWork, there's several others.
Spaces, or I'm not sure which one is still around, but those can be sufficient. But you cannot, and this the last time I priced this out, right? It was a while ago, and they had options where essentially it was just giving you a place where you could go get mail.
Call home. Yeah.
Yeah.
Well, I'll say, look, what's the sacrifice you're willing to make, LaDon? You use your home address. That's what you're going to use or you're going to pay. I mean, and that's just me. Like, I was a rebel for the whole time. I was like, nope, I'm using the UPS. I don't care. Until they just keep denying it. And then it was like they really came cracking down on that in the last 2 years or so. So, yep, go ahead.
If I can say, don't be afraid to be creative. You could sublet a space. Right. Yeah. So if there was another company that you may know, they may be willing to sublet you an office. And trust me, the large law firms here in Atlanta are awash in floor space that they ain't using because no one is working 100% in the office anymore. Right. So if you look for this office space and subleases, I am sure you may be able to find something that's going to be within your budget and that will meet the requirements of, being a quote unquote dedicated desk with an address and a phone number. Wow, but you would also have to have now.
Caveat.
You can't go to your sister and use her home. Right? It has to be that lease has to look like it's an arm's length transaction. So it has to be an actual lease on paper that gives your company the right to have access to and to use that space. So you just can't say,
wait, Carl, what? Wait a minute. Wait a minute. So it has to look legit, not just like, so they're not going to just say, oh, well, it's a different address, we don't care. You're saying it actually has to look legit, like I'm not trying to get over on the system.
Yes. Yes.
Wow.
But now again, if this is just a set, but because she mentioned cage, right? So that suggests she wants to get paid for doing work on federal government contracts. So that would suggest to me that, again, you have to think about what's the environment I'm swimming in here? Who are the sharks? Well, one is any agency that you're looking to get certified from, they're going to come out. If you do DBE, they come out and they make a physical visit. Okay. If you're looking at 8A, they can make a physical visit, so if you're looking in that, and plus, when you start winning contracts, the people that you beat to get those contracts be looking to challenge that award on any basis they can.
Whoa.
I actually had a company that was woman-owned, economically disadvantaged woman-owned, disabled veteran-owned, and hub zone. And they put their office in a hub zone, but they provided engineering services. So most of the people, most of the time, were in the field on projects. And they won a very large project down at a military base in Florida. And one of their competitors said, wait a minute, their hub zone, because they got extra points on the procurement for being hub zone. Their competitor drove by their office several days in a row, filmed and took photos and said, there's nobody in there. The lights are not on. There are no vehicles in the parking spaces. And we had to actually fight that protest and win by arguing that, look, yes, that's our office. We get our mail there. That's where our registered office is with the Secretary of State on SAM, but we are in the field. And so, but that is why on those 3 days, we were on these different projects. And thank God they were on projects and not on the golf course those days. So we were able to beat back that protest from just to let you know, there's the level of concern that you have right now is, what do I have to do to be like legit or to at least look legit? And that's one level. The next level is, what do I have to do to get and keep any certification I might have? And then the next level is, what do I have to do to keep any contract I might win?
Jeez, I never thought about, so we get past I got to register in SAM and use my home address. You got to, the bank has to have my home address, all these different things. But I never considered the competition, the haters, the ones who, and I'm not going to let me not say haters. They want to win and they want to make sure you're legit. So they're going to do whatever they can to discredit you. And you're giving them a reason by not being credible. So that is like something I never really considered, is like, oh, hell no, they're not doing what they said. They're not who they say they are. So we're going to disprove whatever it is that you considered for them to win. That's deep.
And I had a client, and this works for them because they were never challenged. They got a storage unit and made that their office. But to their credit, they went there every single day. They checked and got their mail there. They had a little desk. They had a phone, or they used their cell phone, and they actually worked out of there every single day for, I guess, until they won a couple of contracts, and then they got into an office.
Wow. Your stories are the best, I swear, because I wouldn't even.
It was not my recommendation. It was there. So I'm not claiming credit for that level of creativity. I'm just saying that they pulled that off.
Wow. So I can't just go sit in. Okay, so this might be, don't laugh, but if I go to Panera Bread every day, now I can't get my mail there, right? That's the biggest thing.
Right.
Okay, so that's where the line is drawn. It's like I can't just stake claim like I own this. Got it. Okay. I was reaching, y'all. I was reaching. So we got several questions that came in, but one of the ones was, what is a corporate contract? So I can take it, or you can.
Yeah, that's just, we're talking about government contracts and corporate contracts. Government contracts are with public entities. So these would be school boards, state agencies, federal agencies, state or federal facilities or authorities, entities like MARTA, that would be a government contract. Corporate contracts are with private entities like the Southern Company, Home Depot, Target,
T-Mobile,
yeah,
AT&T.
Delta.
Yeah. Yep. So that's the difference. And the corporate contracts are the ones, if you're getting certified, going through the supply diversity program, it's going to be the ones you pay for. So just remember that if someone's trying to say you have to pay for a federal certification, they're lying to you, or you can pay someone to do it for you, but just know that those are not paid ones. The corporate ones are the ones you pay for. Okay. Just making sure that y'all understand that. And so this is so great. Make sure y'all hit a like on this if you're on, and make sure that you
If there's another,
Mhm.
Sheena, if I could, there's another type of contract I think that may be of interest.
Okay.
There is something known as cooperative purchasing agreements.
Okay.
And what these are is they are third-party entities that essentially bundle government contractors that can sell to public entities. What it does for the public entity is it presents them with pre-vetted vendors so that the entity, the government entity, does not have to go through the formal bidding process, because this third-party entity that has gathered these government contractors together, is vetting the company's abilities and their pricing and representing to the public entity. If you buy from any one of the people through our portal, we have pre-vetted them and their pricing is considered to be commercially reasonable. And there are statutes that allow different government entities, like the Atlanta Public School Board is one. They can buy office supplies, cleaning supplies. They can buy other services, some IT staffing services, through cooperative purchasing agreements.
Ooh, I don't know much about that. I've seen it. Is that kind of what would be like a GSA schedule type?
It is like if you think of it as like a private GSA, that's a very apt description.
Okay. Wow.
But it's not run by the government. It's organized typically by a private entity. Sometimes that entity is organized as a nonprofit, but then they have, like GSA, it's a whole schedule, if you will, of contractors that entity vets and represents to the public entities, the school boards and state purchasing agencies, that they can buy through them without having to go out for bid.
So
I have a client of mine just won 3 $500,000 contracts through a cooperative purchasing agreement for construction materials and cleaning supplies.
I like them numbers, 500,000 each. So what's the name of one of those co-ops? Can you share that, or is that something that?
Yeah, and this one was
or where you can find them, I should say. How do I find a co-op?
Yeah. I will,
and we can do it after. If you don't know what I'm talking about,
we can roll on, and I will kick this out when I re-find it.
All right, no problem at all. So Lena, that's a great question, and I'll take that while Carl is looking. So how do the competitors know? Now, if you win a contract, that's public information. And also with that as well, usually if the contract calls for lowest bid technically acceptable, right? And you're on the call and the agency is announcing the bid pricing, they will announce the apparent lowest bidder right there on the spot, whatever day they decide to read the results. So right then the competitor knows. That person may not actually end up winning, but I'll say maybe 8 times out of 10, they are going to be the ones that win if the agency says, this contract is based on lowest price technically acceptable. Foresight Industries is the apparent lowest bidder, and then they just have to do their little documentation. The agency has to do their documentation in order for Foresight Industries to officially win. But that's how the competitor would typically know. Or it could be, I'm assuming, Carl, like even after when they send the bid tabulation, or they just do the whole award and say the notice of intent to award, and the information is put out pretty quickly usually.
Yeah, depending on the nature of the procurement. If it's a hard bid, meaning all you are basically submitting is pricing, when they open up what they call the sealed bids, the winner is the lowest bidder that is also technically acceptable, and that's a contract. If you're submitting a proposal where you're having to do some explanation for how you're going to perform and deliver the services, then typically there will be a notice sent out to the apparent winner, and then a notice to the others that you are not the winner. And the other way, now in the olden days, they used to send them out, by mail, then by fax, then by email. Now, most times it's just posted on the portal that issued the solicitation. So you need to be monitoring those portals to look for those different notices of award, and also you probably email, you'll get a notice of non-award, and that is how your competitors will find out, typically from those postings or from a direct email.
Now I do want to highlight
those are competitors that submitted bids, right? So if you have a competitor who didn't submit a bid, they would typically only find out the notice of the award when it is announced. Right. But they wouldn't have any right to protest unless they felt you obtained that award through some sort of fraud.
That's interesting. So you're saying someone who didn't even go after the bid, but they feel like you're fraudulent, they can still protest the bid even if they had no interest
right. in it? They could file essentially a False Claims Act with the U.S. Department of Justice to say, oh, I know her. She's actually not running that company. It's her husband, and because she's kicking it in the Caribbean, and it's a complete lie that that's a woman-owned small business. So if they have knowledge of, like, with pictures of you on the beach, right, and your husband like sweating it out, like getting everything done, even if they didn't submit a bid, they would have a right to blow the whistle, to be a whistleblower, and to present that information to DOJ, even if they didn't submit a bid on that contract.
Now that's a hater. That's an official hater. If they're not even going after the opportunity, damn. But that's how you guys know, like, and not to scare you guys, but Carl sees everything usually when it's like magnified or it's about to be magnified. So we're giving you, like, worst case scenarios. A lot of times, not most of the time, but a lot of times things are hopefully not that serious. I gingerly say that. But just know that the feds is watching, and your competitors and everyone else in the world. So yeah, if you're posting that I got this GovCon money, because that's my thing, I got this GovCon money, but it doesn't look like you're performing any work, or nobody in your company or you or whatever, just be mindful of that, because someone is watching. So geez, that's deep. That's really, really deep. I do want to get onto a couple of the stories now. I want to preface this with the reason why these are so important is because sometimes you may not know exactly, what to do in a situation. Maybe you can't afford to hire an attorney, or maybe something's, you have to make a decision right at that moment, and you don't want to come to Carl under duress. Like, oh my God, I need help right now. Like, I'm on the phone with the contracting officer and they're about to fire me. That may not be the best time to resolve it. But if you have some knowledge about certain situations and how to navigate, it could make, help you put your best foot forward. So one of the things I always tell my students is look for errors in the solicitation. And it's better to do that now before it gets to the contract part and you're like, oh snap, we didn't think about that, or it's too late to ask questions. So one of the stories that I told you that I really love was about the guy who was digging in the ground, and the agency was trying to tell him you're doing it wrong, and the guy's like, I'm doing it right, and then the guy ended up being completely screwed in the end. So can you talk about that story again, please?
Sure. So I had a client who was a utility contractor, meaning that what they did is they put the utilities in the ground, whether that is, internet cable, or whether that's, plumbing or electrical lines or whatever. They were the ones, or sewer lines, and happened to be sewer lines in this case, that got them into trouble. And they had done it, and they had used a proprietary process, which they had used in other projects and other locations, which was perfectly fine and acceptable. In fact, even better than the government standard. So they went in and they had identified in the solicitation saying, look, you guys are asking for less than what is considered state of the art in the industry. And so we are proposing something that meets and exceeds what you guys are asking for. And they were upfront and they said, okay, that's cool, but we're looking for this level. If you want to give us something better, that's perfectly fine. He said, look, if you give it to someone who's not at this level, you will have problems. And so turns out that they won the contract, and they were performing it in accordance with their proposal, right? And their proposal was the higher level. The contracting officer, or the using agency who was there on site, said, whoa, what are you doing? That is not what's required by the contracts. Well, the proposal we submitted becomes the contract, or part of the contract, once we're awarded the contract. So yes, it is part of the contract. And they said, no, it's not. You need to undo what you have done and do it the way that it was set forth in the solicitation. So they said, okay. So then they had to undo what they had done on their own nickel. And then they had to redo it the bad way, or the old way, I should say. And when they completed it, there was a failure.
Oh, God.
Because the old way, right, had the problems that my client had designed a solution for. Wow. And it failed. And they said, well, it failed. And my client's argument was, it failed because we did it the way you told us to do it. Now, this gets very inside baseball, very in the weeds, where the question became, did the government give them defective specifications, or did they give them performance standards? And the only way that my client could have won was if the specifications were defective. But what did the government do? They said, those weren't specifications. Those were just performance standards. So after having told them on the front end that what they were asking for wasn't what they needed or wanted, and they winning the contract because they got extra credit for giving a better proposal, they were then interrupted in installing that better proposed solution, had to eat the cost of taking that out, putting in the solution they knew there was a problem with. And when it failed inside the warranty period, they had to come back and fix it at their cost. They bought that contract 4 times over.
Whew, that's the definition of all money ain't good money. Listen, oh my gosh, that story, that's what made me call Carl. Seriously, that story made me say, oh, this guy has got to be on my team, because I've never heard anything like that. And that is so important. Everybody wants to win $1 million contract until you get into stuff like this. You don't want any practice. You guys just want to jump in thinking that everything is going to be the way it is written out. But that is like far extreme. And so this client, that person ended up, you said, paying for it. They paid the government to do it, basically. Yeah. And they ended up going back to the original gold standard.
Yes, that was what they were. They did a change order. Well, they had to fix the failure, right, clean it up and repair it and stop it from failing. They did a change order to then do the gold standard, because by that point in time, the government heard that what they were asking for was not sufficient, but they didn't believe it until they saw it. And then they said, oh, okay, we'll pay you extra for the gold standard. But by that time, they had already installed it once, uninstalled it, installed the less than gold standard, then took care of all the damage that was done and cleaned it up, and then they got the price of the gold standard. So they lost money on the contract and just and lost time because that crew and that equipment couldn't be used anywhere else.
Wow.
So a project that was supposed to take 8 months took 3 years.
Woo! Look, how many of y'all got that kind of money? You don't have that kind of. They went and did it on their own dime without getting paid. So this is not even. Woo, that's deep. 3 years.
And, right, and they might be saying, like, Carl, Sheena, why didn't they just walk away from the project? If you take anything away from this, you cannot walk away or abandon a federal government contract as a prime contractor. That will go into your permanent record, and it will show up in your past performance reviews, and you will likely not ever win another government contract, at least not under that company name.
Right. Yeah.
Because and the only way to truly abandon, I mean, there's ways to leave a contract, and we can talk about that. And you can get a no-cost termination, or you can do a termination for convenience of the government, or you could say, please, please, please don't exercise any options. Right. There are ways to get out of the contract, but just walking off, and here's why. One, it's in your permanent record, as you are a bad performing contractor, but also you will be held liable for the reprocurement costs to complete the project. A quick story. Do I tell quick stories? Probably not. I shouldn't say.
No, I love all the stories. Tell the stories.
So I had a client, and they were brilliant engineers. They designed and installed pumps along the Mississippi River that help control flooding. Right. And for a number of reasons, they couldn't get the Corps of Engineers to accept the testing that proved that the pumps would work. There was a big argument about how much water had to enter the pump before you could test it. And my client claimed that there wasn't enough water when they asked us to test it, so it damaged the pump. So we had to fix it, and they did it 3 times. And they kept telling me, you have to have 67% of the pump filled before you test it. They said, no, you should be able to test it at 50% filled. Anyways, my client got so fed up with the Corps of Engineers, it walked off the job. Just stopped answering phone calls, didn't reply until they got a letter from the Corps of Engineers assessing them $50 million in reprocurement costs, because that was what it was going to cost for the federal government to bring in another contractor, even though that project was more than 50% complete, to come in, assess the scene, fix anything that was wrong, and then complete the job. And we fought as best as we could and got that number as low as we could, but their only answer was to declare bankruptcy. All because they walked off.
Right. So pick your poison, right? So, I mean, damn.
If you want to walk off and that's your retirement plan, is I'm just going to walk off, skip town, and live anonymously. All right, then maybe that makes sense. But if you think you're going to do government contracts after that, think again.
How much was that project? Was it 50 million, less or more?
No, the total project was, I think it was just under 100 million.
And they were 50% done.
And they were more than 50% done.
Wow. And the government was like, I'm putting some tax on that.
Yeah.
And you giving it to us. Who giving up 50 million? Who? Nobody.
Well, think if you're the replacement contractor, what do? You say, oh my God, look at this mess.
Yeah.
This is going to take us so much money and so long to fix this. I don't know if we're going to be able to fix this at all, but we'll try. It's going to cost you, just anyone who's ever had to replace a contractor on a job done in your home, what that replacement contractor does.
Oh yeah.
They make it seem like it's the most jacked up job they've ever walked on.
Right. That is so true. Oh, it's hard. Yes. Who said the government ain't playing? That's true. And I mean, even I've seen this even with prime contractors, where you're a subcontractor and you're pretending like you know what you're doing and you're not communicating because they don't want you to fail. For the most part, prime contractors, they don't want you to fail, because then ultimately if they fail and it loses time for them. So you all like walking off on those, I would say, especially, well, they're both, they're both as important, but a lot of times if you just ask for help, you'll usually get it. Just don't give up and just say, well, I don't know, and just keep on going the wrong way, or just let it go. Cool. Let me see. So, sincerely, Francis, if the contract began under the agreement that it would be done to the new standard, didn't the company have the right to decline redoing under the old standard? And this is for the story that you talked about, the utility.
Right. That was the question about what was the contract for. And we argued that the contract was under the new standard because that was in our proposal. What the agency's position was no, we didn't. We used that only to evaluate your capability, but we didn't accept that as a change in the scope of work. The scope of work was contained in the solicitation. So that was an argument that we had with them, that we did not walk off the job. We did not sue them. We were trying to work it out. So the client said, look, all right, I'll take out my stuff and I'll go back to the way that you say you can't. We had a disagreement about that. So if we declined to redo under the old standards, then what you would have is what I would recommend it is that we file a claim against the government. And a claim against the government is not an easy thing to do. It's a pretty involved process where you have to assert and make a demand as a matter of legal right that you are entitled to something. You are entitled to money to the contracting officer. The contracting officer has a set amount of time where she has to either accept or deny or tell you she needs more time. Once she makes a decision, you can appeal that decision to a Board of Contract Appeals or to the United States Court of Federal Claims. So once you hear words like appeal, Court of Federal Claims, you are right to hear dollar signs, right? So my client was like any contractor. They want to work. They want to make it work. They want to do what their customer wants. So rather than saying, okay, nope, we're going to file a claim, which you're right, they did have a right to do. They said, no, that's going to be more expensive than us trying to fix this and then to get out of this job.
That makes sense. So I do want to kind of go to protests real quick. So protest is to me, it's one of those things like bonding, where it's like it took me a while to understand, like, how is this different from insurance? But I think I might have it now. But when it comes to protests, if, like you said, I'm a hater or whatever the case may be, I went after an opportunity and I'm like, oh, hell no, you guys are doing something shady behind the scenes because I should have won and they should not have won, whether that was the lowest bidder or not the lowest bidder. And I said, I want to protest, bump that. I want my money, right? I want my contract. Now, does it cost me money? Let's just talk about federal for this example. Does it cost me money to do a protest?
It depends.
Okay.
So, and you had mentioned this earlier, Sheena, about when you see a solicitation, you need to go through that thing with a fine-tooth comb, right? And I'm so worried about you looking at all of the incorporated regulations. Send that to me. I'll help you work through those. What I need for you to look through is there something missing or is there something wrong in the scope of work or how they want the work done or what they are or what they should be asking for that they're not. Okay. If there's a problem with this procurement, with the solicitation document, because if there is, your protest could be as simple as sending an email to the contracting officer saying, hey, look, take a look at page 37, paragraph, section L, of your scope of work. And when you look at that, you're going to see you said this, but I really think you meant to say something else, because this is the standard in the industry, or this is what is required under the governing regulations that I know because I'm in this industry, or whatever. And they can take that and before they do anything else, they can issue an amendment to the solicitation. So that it could be as simple as an email as what they call an informal protest. In fact, you wouldn't even have to use the word protest in your email. It could just be, hey, contracting officer, I have a question, take a look at this. Now, many procurements have a formal question and answer part of the process, and you can submit questions, which again are not protests, but you're highlighting and you're identifying an issue, a problem with the solicitation document, and you do that as early as you can. Because if you get an answer that you disagree with or that you think is wrong, you can then send an email as an informal protest before you submit your proposal, or you can do a pre-proposal submission or pre-award protest. And if you do a pre-award protest, you can send it to the contracting officer, you can send it to the Governing Board of Contract Appeals, you can send it to the GAO, which is the Government Accountability Office, or you can send it to the United States Court of Federal Claims. If you go to the Court of Federal Claims, you will need to have a lawyer, and that will cost you money. The other ones you can do in the form of a letter to the contracting officer, a letter to the Governing Board of Contract Appeals, and a letter to the GAO. GAO has their own regulations, are available online, and will walk you through what the necessary parts of your letter are that you have to have for them to consider it. But because you are doing it before proposals are submitted, before the award is made, the agency, it's so much easier for them to fix a problem, right? All they have to do is issue an amended solicitation, or they can stay the procurement and take a look at it. Once they make an award, or once you have submitted your proposal, you have officially waived your right to say there's a problem with the solicitation document. After you submit your proposal, the only basis for you to protest is how they have evaluated the proposals based on the solicitation document. If you want to challenge the solicitation document, you got to do it before you submit your proposal. And that is good. I have won more protests on early protests before bid submission because it's easy. It's easy for the agency to fix. They will oftentimes tell the GAO, you know what, GAO? We are voluntarily canceling the procurement, and we're going to reissue a new solicitation. And you've won. But if you wait until you submit it, now you're basically challenging an award decision, or you are challenging what they call the exclusion from the competitive range, saying that there were a bunch of people that submitted, we looked at them, we evaluated them, and we excluded these because they weren't really competitive. If you are excluded, when you get your notice that you are excluded from the competitive range, you can challenge. But again, you can't challenge based on what the solicitation said. You can only challenge based on how the agency applied the terms of the solicitation to your proposal and excluding you from the competitive range, or ultimately when the award comes out and you were not awarded, your arguments are essentially they erred in some way in how they evaluated your proposal or how they applied the terms of the solicitation document.
I never thought about pre-award protests like is when you ask a question. So if it's after the questions period, which is usually sometimes like halfway through, like if it's April 1st and April 15th might be the last day for questions, it might be due May 1st, something like that. So so if you submit a question after the questions period, after April 15th, for example, does that mean that's kind of falls into the pre-award or pre-award protest?
Yeah, let me clarify. Take advantage of any formal question and answer process they have. If there's a bidders conference or vendors conference and they accept oral questions or they accept written questions, absolutely do that, because you may be able to get them to answer your question in the way that you want. If they don't, you can send a letter saying, hey, look, this letter is an informal challenge to your interpretation or your application or your inclusion of this term in the solicitation document. So if you're in if you're before or in the formal questioning process, you can just treat it as a question. Once that final question and answer process is done, but before you submit your proposal, now you're more formally saying, hey, look, something's wrong here, and you really need to fix it. Rather than just like, hey, I'm just asking questions, right? That's the friendly part. That's the I'm not challenging part. But if you've done that and you've not gotten them to where you need them to be, then you're in the informal pre-submission protest round, where your language is a little more direct and aggressive. Yes.
Oh my God, this is a life changer. This I swear, because I know some of the people that are on the call, on the YouTube, are new to government contracting. But for anyone who has found a solicitation after the questions period, we're talking about you just looking for bids online, right? And you're like, oh my goodness, the last day for questions was yesterday. I didn't even know or really understand that there's a more direct and aggressive way to say, hey, this is wrong in here. You know, you didn't answer this question it's wrong, and no one asked and no one answered the question during the questions period. And or sometimes they don't even get you the questions back until like damn near the day before, you know, the proposal is due. So that is, I didn't know that was like something that you can, the way to do it. So like you said, if you're just like, hey, I know the last day for questions was last week, but I have a question, you can't say it like that. You got to say, I'm challenging this BS that you got on this solicitation. And I'll give you an example of something that happened with me as a subcontractor. I was like a sub of a sub for a federal contract, and we were going to be doing a cleaning portion, and it was for a huge 2 million square foot facility with every single federal agency you could think of, Department of Labor, Department of Education, Social Security Administration, Corps of Engineers, all these people. And there was damage, let's just say vermin damage on lots of the documents. And so what their contracting officer, the prime, and everyone in this process above me said is this, oh, just throw those contaminated documents in the dumpster. Now, not just me being a cleaner, but me being an IT for 20 years, we know better. Nothing's going in that dumpster. What are you even talking about? But no one said anything. No one thought about it. No one cared. But I said, that's fine. You guys can throw it in the dumpster, but we're not. We're going to bag it up, and whatever you do with it, you do with it. So those type of things is like, okay, not just looking at what they're telling you, but even if you're a sub, even if you're the lowest person in the totem pole, if something doesn't make sense, you need to follow whatever you understand to be true. Okay? Just leave that at that. Beat a dead horse. So a question that I have for you as well is what do you see in contracts? Maybe one or two things that you see in a contract, or really a contract, that's all that really matters, that it ends up being like the death of a company. Like if they don't have it, the jurisdictions in New York, and New York is crazy, that's usually the death of a company, or they don't have something in particular.
Generally speaking, the ones that I see that get people in trouble relate to the payment of employees. Ooh. So wage an hour and prevailing wage, particularly for people who are new to government contracting, who may have a track record in commercial, right? Because your large commercial clients don't really care what you pay your employees or what your subcontractors employees get paid. They just need the job done, or they just need the products delivered, right? But the federal government does care. It does care that all the employees on a contract that's being funded with federal dollars, that the employees are paid in accordance with all of the federal laws, right? So if you have people who are wage employees, they need to be getting paid overtime if they work beyond the number of hours they're supposed to work. And you can't just say, well, I'm paying them, I have them on salary. Well, not if they're in a category of employee that doesn't qualify to be treated as exempt from wage and hour. Now, I'm not an employment attorney. So I have friends of mine that do that I bring in on these kinds of cases that will help make sure that you stay on the right side of wage and hour, because that can kill a company. Absolutely kill a company if you are just blindly paying salary to people who should be on hourly wages, and it gets found out that you owe overtime to them, because you can get hit with the money you did not pay them and with penalties from the federal government. And it can lead to you being suspended or debarred from getting future government contracts.
Ooh.
And it can put you under monitoring from the Department of Labor. Okay, so that's one that I see. And it's typically not people who are new to business and new to government contracting, because those folks only know what's in their contracts, which is Davis-Bacon or the Service Contract Act and the DOL wage and hour. It's people who were, hey, I know how to do this. I've been doing this for 20 years in the private sector. Yeah, I can beat these government contractors because I can price, on the lower end, and I can win all these contracts, and they can. It's only when people start taking on and say, hey, wait a minute. Your prevailing wage doesn't indicate any fringe benefits.
Right. Ooh. And that's for an extra $4 an hour, pretty much.
Yes.
Oh my! Over 10 years that you've been doing this contract, or whatever the case may be. Imagine that back pay.
Well, and the other thing is, every time they submitted an invoice, they were making the representation that they had previously paid their employees compliant with the requirements of the contract. So not only did they have the monetary deficit they had to make up, they had to explain why they basically lied on all of the previous invoices. So those are the kinds of things that are like people shooting themselves in not even the foot, shooting themselves in the head, but just by being grossly negligent of what their obligations are as a government contractor.
Saying you don't know is not enough, and everybody want to be their own HR. They're like, oh, I don't need an HR. My sister does it. Okay, well, I was the person that had to pay back. Now, mine was only about $6,000, so that's a lot of money. But luckily, my HR was like, I brought in someone. She was an expert. She works for my company. She's like, yeah, we have to go all the way back. And I'm like, all the way back to what? Like, I didn't even know that it was a thing. I didn't know that I was doing anything wrong. Just like you said, and ignorance is not bliss. And they don't give a damn if you didn't know. Yeah. And I had to go back and incrementally pay. And it wasn't, found out. It was found out internally before it got too out of control. So you have to be ready for this. Y'all have to be ready for these things. And if you do it right, everything's going to be fine. So just do it right from the beginning. Stop trying to cut corners. Okay.
And just to be fair, and not to make this like an episode of Scared Straight, is that typically the DOL doesn't look to find people like intentionally violating the law. I don't want to say that they will give you the benefit of the doubt, but they understand if mistakes are made, right? But you can't, if mistakes are like, one or two, right? You can't be consistently ignoring your requirements for 6 years and expect the DOL to say, oh, well, this is not a systemic problem. This was just a one-off. Like, no, you've done it for 6 years. This is the way you do business. This is a systemic failure. And that is when the hammer comes down. The other area I will say, and this doesn't apply to everybody, but on any government contractor where you are making a representation about the origin of where your materials or components come from, like the Trade Agreements Act or the Buy American Act or the Buy and Build American Act, you need to understand where you are getting your materials or your components and where your subs are getting their materials and getting their components. Okay, because that you can't if you require your subcontractor to represent to you that they will only introduce into this project materials that satisfy those 3 agreements, then you can argue, hey, look, if they did it, they were lying. They weren't just lying to you, they were lying to me as well. And I was trusting the representation. But if your subcontract is silent and doesn't extract that promise from your subcontractor, your suppliers, well, then you are going to be on the hook for the failure of your subcontractor and supplier.
Ooh, y'all remember the movie War Dogs when they repackaged?
That's a great movie.
When they repackaged those bullets, it was a problem. Okay. And we don't need you guys doing that and messing up the market. So, wow, that is, those are really good examples. Like you said, I don't want this to be scared straight, but the government pretty much, for the most part, with the exception of those errors that you're going to become aware of when you're reading the solicitation, they're telling you what you need to do. So if you're just trying to figure out a way to get over, you might win today. It's just like the IRS, right? You might get away with not paying taxes for 10 years, but year 11, when you need your money the most, they're going to snatch it out of your account and you're going to wake up and the money's going to be gone. It's the same thing. It maybe not today, maybe not tomorrow, but just do right, do good business, and good things will happen. Okay. So we got another question from Lisa Brown. As a sole proprietorship or a single employee LLC, if one dies or gets sick during the performance period, does it go against one's estate? Will the U.S. come to sue an estate if no negligence? Damn, that's a good question.
Okay, so I'm assuming in this question that the sole proprietorship single employee has a government contract performing it, but it is not complete. And then that person who is the sole member LLC passes away. Okay. In that instance, if there's no automatic rights of survivorship to somebody else, like if you have an SDVOSB company, a spouse of the qualified disabled veteran can step into the shoes of that disabled veteran if and when they die and can complete the contract, even though that spouse was never a veteran. So there are some instances where someone can step into the shoes and then they can complete the contract. But assuming that there's no survivorship, there's no succession plan, it's just a sole member person providing services or whatever, and that person dies. Well, what will likely happen is that the government will, however it finds out, right? That the contractor is not performing, not showing up, not being responsive, they will likely declare that the company is in default. At some point in time, they will learn the default was a result of a death of the single member LLC. And I don't know of a case where the government has come back against the estate to say, because it's not the estate
doesn't own the
LLC unless it was set up that way, right? So it's a single member LLC. The obligations of the government's looks to the company to perform its obligations. So it might get a judgment against the LLC, but unless someone has provided a personal guarantee of the LLC's obligations, there's not really a legal way for the federal government to reach the estate.
Wow, that was a really interesting question. I had never thought of that. So that's the same thing for children, right? Can children step in if like say there's no spouse? Can a child step in?
It's been a minute since I've looked on those rules with regard to, and that, as far as I know, that's for disabled veterans. I don't know that they have that for a woman-owned business. Typically, however, and this also applies when a company gets acquired. So say you have a woman-owned small business that has ongoing contracts that gets acquired by someone who's not woman-owned. They will have the right to complete the contracts so long as the agencies agree, right, to have the contracts continue, but they're not allowed to get new contracts because the ownership has changed.
And I'm glad you brought that up because before we started this, the live, you did say that you do acquisitions and mergers, and
Yes.
people know for what I teach is you're building to sell. Even if you're not going to sell, you don't want to pass down junk, right? Or pass over junk. So can you explain a little bit about like what you do in that field? And is it really
Sure. And
government
this
contracting?
comes up a lot, particularly in the small government contractor space, because a lot of folks, if they go into the 8A or they go into the SDVOSB, they understand that those certifications, which are valuable, have a limited shelf life, right? The 8A program is 9 years. The SDVOSB status is only good for that particular veteran or set of veterans who own 51% of the company. So once they pass on or they want to retire, then those statuses are going to expire. So what people often try to do is when they have a woman-owned small business or just a small business, or they have DBE, they look for, okay, what's our exit strategy, right? Am I going to pass it down to somebody, or am I going to sell and dip out? So if you're going to sell, one of the first things that's in the process is understanding the owner, helping the owner understand what's the value of what they own and what they've created. Okay. And in government contracting, it's a little different than just a private company. So, and the other thing I recommend is, if just because you're a government contractor doesn't mean you can't sell to private entities, right? You want to have as many different kinds of sources of revenue as possible for your company. But say you have mostly or all government contracts, you want to get an accountant to help you evaluate and value your company, so you can have a knowing understanding of what you have, what it's worth, and why. Okay. You don't want to be putting out like, oh, well, I have, a good reputation, and that's worth $6 million. Like, no, that might fly.
Because I'm me. It's because I'm me. That's why.
Right. So you want to be looking, and it's not just the value of your current contracts, particularly if you have a track record where you have, grown your annual revenue that you have, or your receipts from government contracts over the years. Then when you are projecting forward the future value, you have to take into account what that track record is, right? So that you can say, oh, my first year I did 2 million. The second year I did 2.5. The next year I did 5. Then I did 7. I'm now doing 12. So, and it's not like, well, it's worth 12 million. Well, no, it's maybe worth more, because you'd be able to build on that track record. So understanding the value is the first thing. Then part of understanding value is also understanding liabilities and risks. So when I represent someone who's going to buy a company, we dive into the contracts and where are we on performance? Who are the key personnel? What happens if we lose a program manager? Right. What happens if this is a staffing contract and 2 of our PhDs say, nah, if I can't work with Sheena, I don't want to work with anybody. Okay, so what's the risks and the liabilities that are part of the assets that the company has? And assets, obviously cash. How much cash do you have on hand? What are your contracts worth? What are your debts? What are your liabilities? Do you have a line of credit? Do you have an SBA small business loan, right? Did you borrow money from Uncle Joe, right? Is there a promissory note? So digging up all that stuff, and then also looking at what's the CPARs, what is their actual reputation as understood by the government. Diving into all those things from the buyer's standpoint can help them make sure they know what they're buying. From the seller's standpoint, what we're looking at is, what do we need to clean up?
It's like the dentist, right? It's like the dentist.
Exactly. Do we have to get Uncle Joe paid off before we put this thing out to market? What about this SBA loan? Can we get this refinanced? Or any other things that would make you look better and more solid to a potential buyer. And then to help them go through the due diligence to say, hey, I want to see your evaluations, your performance evaluations. Okay, we make sure that we provide them. Well, I want to see the contracts. I want to see the change orders. I want to see the contracts that you are bidding on in this coming fiscal year. Right? I want, what are do any of these contracts have options? Okay. Where are you in your schedule of certification renewal? Right? If you're SDVOSB, are you a member of any joint ventures? Where are they in the joint venture 2-year life cycle? And I know that's the first time we talked about joint ventures, but in federal government contracting for small businesses, a joint venture can win as many contracts as it possibly can in a 2-year period. And that 2-year period starts with the award of the joint venture's first contract. So you win a contract January 1, 2024, the clock starts ticking. And then come January 1 or December 31st, 2 years from now, that's when the clock stops. And then you have to not submit any more new bids under that joint venture. You can reconfigure and create a new joint venture, same 2 parties, but different UIE, different tax ID number, and call it a different name, and you can still hunt contracts, but you can't do it after 2 years after that contract award is initially made to the joint venture. And how you count the 2 years gets interesting when you talk about option years and renewals and extensions and things like that.
You can continue to perform them until they run out, right?
Exactly. And that does not stop the clock except for submitting, and you can submit on the last day of the 2-year period and get awarded a contract 2 years later and still perform it under the original joint venture.
So that's a good point, right? So let's just say that we won a bunch of one and dones throughout the 2 years, but then on December 31st, we bid on something, we get awarded 2 years later. In my mind, I would think, okay, we haven't won anything in a couple of years. Let's just dissolve the business. So is there like a standard, should we keep it open for 5 years? Like
I would keep it open until the expiration or the decision is made on the last contract you bid on within that 2-year period.
Gotcha. So if any loose ends are still open for that, just keep it open just in case.
And it's interesting because you say you submit a bid 6 months before the end of the 2-year period, right? And then you learn, like in November, you didn't win, but then you file a protest.
Oh.
So now that protest, they can have 100 days to decide a protest at GAO, and they can have 3 months or more at the Court of Federal Claims. So now you're well past the 2-year period. You win the protest. Then if they award you the contract, you can perform, even though it was awarded outside the 2-year period because you submitted it before the 2-year period ended.
Wow. And all the while you're bidding on new contracts. So you're like, wait a minute, we gotta halt this thing. We got a lot of stuff going on. So we got a few more questions and we got about 2 minutes and we'll be at 2 hours. And I don't want to talk Carl to death, but get your last few questions in.
If I can just, Omnia, OMNIA is one of the cooperative purchasing agencies we talked about. And there's a National Institute for Government Procurement or Intergovernment Procurement, NIGP.com. That's also a good source for looking at the cooperative purchasing entities and opportunities.
You said the first one was Omnia,
Omnia, OMNIA.
Oh, man, it's about to be on and popping, y'all. I'm about to be going after these, hopefully with Carl's help. All right, so a couple more questions. Get your last few questions in. So LaDon Malone said, there's a lot of money out there. I guess I would just keep it moving. I guess the time it takes to protest, you could possibly be in another contract. Very true. Pick your poison, right?
And you want to make strategic, not emotional decisions, right? You put all your heart and soul and time into winning this contract, and you're like, how did I not win this contract, right? And you're like, oh, hell no. I'm going to win this contract. So they're going to give me this contract, right? And you call me and like, oh, you want to fight? Let's go, baby. I'll fight for you. I'll fight with you. And it's like, okay, well, here's my first bill. Carl, I had no idea. it was going to be this amount. It's like that.
Right.
No one's happy in that situation. So you really, some of the best advice I have ever given to clients has been to not protest.
Wow. He said, don't even give them the money because it may not even be worth it.
I've looked at it. You have some arguments. They are not the strongest arguments. It'll be a long, expensive process. Go fry other fish.
Ooh, look, somebody put that in the chat. Go fry other fish. There is too much money out here. If we're talking about a $50 million contract, okay, maybe. But if we're talking about a $15,000 contract, that may not be worth the juice and the squeeze. May not be worth it. Okay. So next one is okay. That I saw this question when you were answering, Carl, about the when you go to protest or even like the challenge. Have you seen where contracting officers, this is a human business, right? But have you seen actual issues where a contracting officer is like, this person's a troublemaker and they'll do everything they can to keep you from winning? Or I guess officially they can't, right? But
yes and no. And let me tell you, if you are in government contracting for 15 minutes, not 1 minute, but 15 minutes, you will be affected by protests. Either you will win a contract and get protested, or you will lose a contract and you will protest, or you will want to protest. It is part of the game. I'm here to tell you, Lockheed Martin, those guys, Northrop Grumman, Raytheon, they don't hesitate. If they think that they have a basis for protest, they will file the protest, and the contracting officer doesn't blink an eye. Right? It is the smaller the contract, the smaller the universe of interested parties, the more those kind of personal grievances come into play. I had one of my most satisfying victories was working with an ACDVE, which is an airport concessionaire disadvantaged business enterprise. This is it's a very involved saga dealing with certifications and joint venture agreements and bad actors in the public entity and with the joint venture partner, which took 5 years to ultimately resurrect and to win. Now the personalities there became very offended by the fact that we were asserting our rights. Because it was way more attention and way more time that they had to give to any other ACDVE at the entire airport ever. And because we were dogged in our advocacy and pressing our rights and using every administrative opportunity we had to press our rights, they looked at us like we were troublemakers. But that was because it was over one contract on one terminal at one airport. So we were the making a mountain out of a molehill, putting a tempest in a teapot, right? That this could not be this important. And why didn't we just settle and walk away? And when I had a client that was very committed to principle, and she was right. She was proven right in 4 different courts. And ultimately, we finally got them to resolve this issue, but it took the better part of 5 years. And yes, they did see us as a troublemaker. And that is something that my client had to live with during that process and after the process was over. But in the assessment for that company, it was worth it to them. But for
a large contract?
But it was large for them.
Yeah,
but it was not a $100 million contract. It was not a $50 million contract. It was not a $25 million contract. So it was, again, it did to the people on the other side. They did not think that we were acting reasonably given the amount of money that was at stake. But for our client, the principle and how that company was treated as a disadvantaged business enterprise
Yeah.
was not right. And we weren't going to quit until we made it right, or someone told us it can't, they weren't going to make it right.
Look, the
So
airport is rough. If y'all trying to get into the airport, woo, you got to have
just
your
and understand that if you're going to fight on principle, good on you. And I've taken clients on, but understand that can be a long process. It will be an expensive process. At the end of the day, even though you may get what you were fighting for, you may have changed the environment in which you now have to perform those services.
That is
exactly now, if you're going after a large federal contract and it's like a $50 million contract and there's 25 bidders, you best believe people are going to protest, right? And if you think that you have a shot and you were done wrong, they are not going to think any worse of you for being one of the 12 companies that protested. That's just part of doing business with the federal government.
Someone told me a while back, I don't know if I was at a conference or they mentioned it, and they said that they do an automatic protest every single time. So does that like delay? Like, I get, based on what you're saying, it's like, yeah, because I'm sure there's something wrong in this, right? But does that like kind of delay, give you an advantage as far as time? Like, what would be the reason to just automatically do it every time?
Well, I'll tell you, and here's a little tip. If you lost a federal government contract, the place to protest for me is typically GAO. One, the requirement, it's much less formal than Court of Federal Claims. And there's a statute that says if you file your protest within a certain amount of time after the award decision or after you get a debriefing, the statute automatically requires the agency to stop the procurement process until the protest is decided. So if you're a protester, that's a great piece of leverage because it stops the process right there. Okay. And then once you stop it, you go through the protest process at the GAO and you get a decision. If you are the awardee, you can ask that the stay be lifted if there's some kind of emergency. And I've had that happen. There were some folks, you might remember a couple of years ago, there were some tornadoes in December in Kentucky a couple of years ago. And there was a large federal contract for emergency debris removal, right? So they could get the electrical lines cleared and the roads cleared. Yes, thing. Exactly. And a protest was filed, stay kicked in automatically. The winning contractor moved to have those stays removed, and GAO removed the stays. So on both sides of it, as the protester, you have that automatic stay at GAO, but you also can seek to have the stays lifted from GAO if you are the awardee.
Okay. All right. So it kind of like, it seems like it might move things a little faster. Is that what you're saying? Like it might. Okay.
Yeah, but a protest slows down the award process until the protest is decided. Typically, GAO has 100 days from when they receive the protest to decide a protest. And Court of Federal Claims typically has a goal of deciding protests within 3 months of filing.
Got it. Okay. All right. Right. So we're getting lots of kudos. This is great information. We're over the 2 hours, but there's still a few more questions. So I'm going to hold you hostage a little bit longer, Carl.
My pleasure.
We appreciate you so much. Okay. Yeah. Your company be fine and have all kinds of problems going forward.
I don't know about fined.
Yeah. Fines, maybe not, but disciplined in some kind of way. Let's see here. JV. This is so some of these questions I'm not gonna cover right now because they're more like just regular government contracting questions. And we can talk about that at a different time. So there was one more question I had for you. Well, a couple more questions. So we talked about it offline. Are you taking new clients?
Yes. Okay. And I may have mentioned this early on. I have 2 companies. My law firm is Gebo Law LLC, and that is where I am a legal advocate, legal representative. I am your lawyer, your attorney, and I represent government contractors in bid protests, contract negotiations, litigation, lawsuits, arbitrations. Also do a lot of advising on compliance issues and responding to notices that you might receive from the government, kind of soup to nuts when it comes to representing government contractors. I have a second company that I set up, which is called GCARL LLC. That's a consulting company where I coach, train, instruct, advise, and guide, not as a lawyer, but just as someone with knowledge about the government contracting area. And I help y'all help yourselves. So when it comes to like, oh, Carl, I want to apply for an 8A. And I was like, okay, well, let's talk about that. I can do that as a consultant. If your 8A application got denied and you want to appeal that denial, I could help you as a lawyer to appeal that decision denying your 8A status.
Got it. Okay, so everyone
I'm taking new clients, and if you go to my 2 different websites, there are portals through which you can schedule meetings. And just as a lawyer, I have to be cognizant of conflicts of interest. So if you'll see on my Gebo Law LLC website, there's a form you would fill out before we speak, so I can make sure that there's no conflicts.
Yes, so don't be trying to find him and then call and say, hey, I got a question, because he's going to charge you. Rightfully so. He paid a lot of money for his education. And as you can see, he just got so much information. We can't even squeeze it into these 2 hours. So I just want to give a quick story where I feel like Carl kind of like saved my sanity with one of my contracts. I had a horrific contract. It was just all bad, all kind of way, all bad. And my nerves were just shot. And I called him early in the morning, like full on panic. And I said, I got a termination for convenience. Right. And his reaction was, it was like when you go to a parent and they have a different reaction to what you thought. And you're like, oh, thank God. He was like, oh, that's great. I'm like, what do you mean that's great? He was like, that's a get out of jail free card. You good. This is all you need to do. And I was like, oh my goodness. Because if you hear termination, to me, that's imminent death. And just knowing that you have someone like that on your side where you can bounce those questions off of, and, you know, things that just, like I said, A, B, C, but you don't have D, E, F, and you maybe have the rest, you need that gap. You need someone to help you fill that gap. And like government contracting can be so confusing already, but the last thing you want to do is not be compliant, because like as all the examples that we've given, that Carl has given, it could be the grand opening and grand closing. So we don't want that, and your sanity and everything else that comes with it. So we don't have any more questions in the field, but make sure before everyone logs off before we log off that you go ahead and hit a like. I'm going to put all his information in the description. Yes, sir, please.
Before you call me, I mean, unless you are already like, you want to protest like next week or something like that, there's a lot of free information and resources you should absolutely take advantage of. Here in Atlanta, the SBA office puts on different classes all the time. They're all really, really good. Also at Georgia Tech, they have an Apex Center, which is a training center, a technical assistance center for government contractors. And again, it's all free, and it's great baseline information for you if you're just starting out, or you're just exploring it. I highly recommend those two before you start paying for courses or paying for someone just to have a conversation. There are free resources out there that are very high quality, and you can get on emailing lists, and they'll send you articles, and they'll send you go to one introductory session at Georgia Tech. They will put you on a list and send you opportunities to bid on for your NAICS code for free.
For free. And
so those are great resources and opportunities for you guys to educate yourself. And like I said, I can help you in a couple ways. I can do it for you. It's the most expensive. Right. I can do it with you. That's less expensive, but it's going to involve more of your time, because you're going to learn together. Or you can do it and I can help you. And then if you do that, soon you can do it on your own, and you only need me when there are sticky questions.
That's right. That's right. Thank you so much for that, because I tell you guys all the time, free first. Free first. That's what I had to do when I had not a two nickels to rub together. I had to go down the, SBA, P, it used to be PTech, now it's Apex Accelerators, YouTube University, to learn, because I didn't have the money. So just try to learn as much as you can on your own. Either time, money. Those are the two things. But don't come to Carl talking about I'm brand new to government contracting, help me, because that's not going to help him. That's just too much stuff to explain to even get you really to where you need to be. There's certain parameters there that you have to have an understanding about. At the very least, understanding the business. At the very least.
That's especially true in government contracting, but it's true for every entrepreneur. At some point in time, you're going to have to decide. Every entrepreneur, when she starts, does everything herself. Then quickly she learns she can't do everything herself, because that's not the highest and best use of her time. Now, she may have limited resources, so she has to prioritize. What am I going to pay for?
That's right.
And then as you get going along, the stuff you do becomes less and the stuff you pay for becomes more, but you can afford it. And it's a reasonable and rational decision. So yeah, that's something all entrepreneurs have to learn, but especially so in government contracting.
Absolutely correct. So we are 2 hours and 15 minutes. Carl, you have been amazing. I appreciate you so much. How many times do you get to talk to an attorney for free, y'all? Like, this is beautiful. And he gave you
Sheena,
all.
thank you so much. This is absolutely a pleasure to chat with you and to chat with your audience. And this is what I do. This is what I've done for almost 30 years. And I get excited, about it. I get excited working with new companies and entrepreneurs, and particularly, small business, minority-owned, women-owned, disabled, veteran-owned, 8A companies. I am here for that community because they have the same needs as the large businesses, and very few people that are able to help them. And it brings me joy to do that.
He means that, because I'll be like, help. And he's always like, what do you need help with? It's always so calming. So I appreciate you again. And until next time, you all, it's your favorite veteran. Peace out.